Good evening, everyone. And without wasting, sorry for the late commencement. I've been in a meeting from 10 a.m. until 9:20 p.m. So we couldn't start as we wanted to start, but the good thing is that we are here and most of my panelists are also available. So panelists, thank you for being here. So maybe let me be sure. We have lawyer Ezekiel here. We have TK here. Ajua, Sam, are you around? Loretta, David, Belinda. Okay, I think there's somewhere there. Okay, so this is what we are going to do. This is not time for extensive exposition and presentation. The purpose of this is just to give you the opportunity to provide you just, if you like, some last minute guidelines and help address maybe some challenges that you may have. So we're going to have like an ordered or a structured approach, and this is how it will be. You raise up your hand and then you are called to ask your question or make your point. So let one person be talking at the time. Let us control our mic. If you are not the one talking, make sure that your mic is your mic is off. Yeah, the person who just reminded me, somebody asked me to explain how to write a memo. And as a person to remind me when we come online. So thank you very much for reminding me. We'll be dealing with it. Okay, so because you have started with that, the question we had was that from the person that if you have to write a memo, how do you go about it? I have said it before, and I'm repeating it before my other panelists will come in, that you shouldn't be so much, worried about you being asked to write a memo or you being asked to write a legal opinion or anything. It's not so much about the form as the substance. The reason for saying this, as we've said before, is that LLB, you don't have, apart from a legal writing, you don't have like any full-blown or full course on drafting. So that is not the focus. So the focus is on the substance. And if you have to do a memo, I mean, the only thing in practice, what happens is that you write memo at the top, and then you indicate from you, the author, to the whoever you've asked to write the memo to. So from then colon your name, but because it's exams, you are not supposed to write your name. And that is why I said that the form is not so important, okay? Because if you write your name, according to the rules, if you give any indication regarding who you are, it's like you are trying to rig the system, and that is not good. So you don't want your name to be indicated, because it will go against you if you are not lucky. So avoid writing your name, just use your index number. And then we have like the subject matter. And usually a memo is just like, if you like, an essay. You must have introduction. Introduction, you tell us the purpose. Why are you writing? What are you seeking to achieve? And then what exactly do you want to address? You signpost us, in the aspect of the introduction. Then you move on to develop the various ideas, remembering the basic principle about paragraphing, one key idea to one paragraph. And because you're doing handwriting, you're not doing word processing, we have said that in order to let your paragraph stand out, it will be a good practice, for example, to do the indentation as is usually done, so that we know that you are leaving a paragraph, as it were, instead of just leaving one line between paragraphs. That one is not really necessary. You could just do the indentation. and that should be fine. So that is what we say about like the memo. And of course, you must also have a conclusion. So you have a good introduction, the body, one main point to one paragraph. Depending upon the type of work you are doing, sometimes you may even have, if you like a bit of like subheading, assuming that is necessary for the type of subject matter you've been asked to write the memo on. Otherwise, introduction, the body, and then you have like your general conclusion. Yeah, so those are the initial suggestions I can make concerning the memo. So I'll come to my panelists. So I don't know if Loyatik, are you there? Okay, Loyatik is not there. So I don't know if you have Ezekiel. Ezekiel, can we hear you? Do you have anything to say? Yes, can you take it? Yeah, with respect to what the person would like to know about writing a memo, do you have any other points you add? Yes.
I think your line was breaking a bit, so I didn't hear you well.
Oh, right. I think that somebody asked that if you asked to write a memo, what should go into that? And I explained what should go into that, but I wanted to find out if you also have some additional points to make.
Not very much. I don't think I have anything useful to add to what you've said to them. Yes. But what I would say is that they should always bear in mind that the substance is very much important than the form of what they will be required to do. So if in any case they are asked to write something in a particular procedural form and then they don't know, I think that they should focus on the usual substance of what they know from the faculty level and then just write it like that. Yes. So I don't think I have nothing useful to add to what you said in that regard. Yeah.
All right. Thank you. Good. So we will take the next person who has a question or anything to share, because the purpose of this meeting is to share information, compare notes, and also see guidance where there's a need for one. So if you want to do that, raise up your hand. I notice someone's hand is up. Let me see if I can see the person. The person whose hand is up, just mute yourself and start talking. That is Anyimadu Antwi, yeah.
Doctor, good evening.
Yeah, good evening.
Please, I wanted to find out whether, with regards to the memo,
yes,
I heard Senior Ezekiel saying it doesn't matter, the substance is what matters and not the form.
Yes,
the memo.
Yes.
So the memo is to, from, the date, and then subject of a memo.
Yeah, so as I indicated, the form is not important, but since a good number of you are facilitated by the form, the advice I'll give is that you have like a heading, okay? You have a heading, and then the heading just have like memo or memorandum, other memo for short or memorandum. And then you have next line, you have from. You can put your name there, like not your rare name. You can just put your index number, or depending upon whatever you use to just put anything there. And then the next one is to, like the to, you do the colon and then you put like the name there, like the whoever you've been asked to address the what do you call it? Whoever you've been asked to address the memo to. And then the next one, you have like the subjects, okay? the subject, or some people will say array. You just write the word array, colon. But if you write subject, it's simple. You write subject, then colon, so that the particular topic, right, which you are writing about, you write that there. You underline it and you start, you have your introduction. The usual introduction, what does introduction do? You let us know why you are writing that memo. What has led to that? What are you seeking to achieve? What do you want to address in that memo? Then you do like the roadmap or like the signpost, what you are going to advance in that memo. Then you move on to develop the body. Taking one, as I said, one point, you develop it into a paragraph that way. Depend, sometimes you may have maybe like a subheadings, not all the time. Sometimes you may have subheadings. If you can do subheadings, that is fine. But ultimately, when you have finished the full body, then you have your general conclusion. General conclusion, as we know, conclusions like trying to pull your main points together, and then letting us try to respond in a brief or in sum to the heart of, if you like the question, in the light of all that you have done. So that is the point where you are done. But again, to reiterate what I said and what Ezekiel and my other colleagues have said before, don't be worried about the form. Pay attention to the substance. Okay, so we move on. I don't know, Kodjo, if that helps you.
Yes, Doctor, it helps. Thank you very much.
All right. Okay, so we take another person. So while waiting for someone to raise up his hand or her hand, somebody has put in the chat, please, can you guide us on how to answer a question on corruption, galamsey, and homosexuality, with chapter 5 of the Constitution in mind? Okay, thank you. My panelists, there's a general question that using our understanding of chapter 5, which is the fundamental human rights and freedoms of the 1992 Constitution, how may we address questions pertaining to corruption, galamsey, and homosexuality? In our previous lectures and interactions, and yesterday, when I had Dr. Bassett here, we talked about some of these issues. But the initial points or suggestion I will give, and then I will yield to my other panelists, is that your exams, the way that they do the questions, especially the essay questions, the trend I see is that there are of two main kinds. Sometimes they bring the essay question in a very general form, okay? For example, just like maybe corruption. Maybe the issue of corruption has become a national concern for quite some time now. Discuss ways in which this may be reduced, or the same thing about, let's say, like the galamsey or homosexuality. So this is, if you like, a very general way of putting the question. So that's one way. And they also have like a specific way where maybe you could be directed that to what extent maybe does the Ghanaian law adequately or inadequately addresses the issue of, let's say, galamsey, right, or corruption or homosexuality. Now, if the question is very specific, that one, you don't struggle very much in how to organize your ideas, and for that matter, your answer, because the specificity or the specific nature of the question itself is, as it were, directing you. But where it is very general, and when it is very general, you may even be tempted to forget that you are a law student, right? And then you just start talking like someone who has not studied law before, like maybe any political science student or sociology student or journalist or any lay person who just knows English language. That is the danger. Don't forget that this exams is not exams you are going to write in order to get admission to start LLB. Maybe to get admission to KNUSC or get an admission to University of Ghana or KPUS or GIMPA or UPS or PUC or wherever. That is not the type of exam. This one is exams you are doing to get admission to professional law school. So the assumption is that you have learned law at the undergraduate level already. So when any question is asked, the exams are going to do is a law paper. Even if the question by itself does not appear to be presenting itself as a law question. Being a law student, a law graduate for that matter, you must never lose sight of the fact that your approach must be legal. And what do you mean by this? So you have like a generalized question. As a good student, you must always remember what we call the hierarchy of legal norms. Our constitution is always the first layer of legal norms, followed, in terms of Article 11, followed by Acts of Parliament, delegated legislation, the common law, including the case law and all that. So all the time, be guided by that. So if you have, let's say, a question on corruption, you must know that the criminal law has got something to say about corruption. You must say that the Constitution itself, the Constitution talks about probity and accountability, isn't it? If you go to the preamble of the Constitution, and then you also go to even Article 23 of the Constitution, talking about administrative justice. All that have got some implication for corruption. And of course, even directive principles of state policy and all that. And not only that, there are some other ways in which the Constitution, for example, directly and indirectly seeks to address the problem of corruption. We know the Office of Auditor General. Part of its work is meant to address that. The Code of Conduct for Public Office Holders, declaration of access by those who take public office and so on. So all these are meant to address the issue of corruption in public office. And then you come to direct criminalization. You go to the Criminal and Other Offenses Act 29, as variously amended. You know that there are provisions on maybe taking bribe or giving bribe and so on. And all these things have got something to do with what? With corruption. So if you have a general question like that, you should be able to bring these ideas together. And also, that's why you've also learned a bit of like legal philosophy and jurisprudence. Despite the fact that jurisprudence is not part of the 6 examinable courses. Aspect of it is reflected in Ghana legal system and legal method. And for that matter, if you have like a general question, there's nothing wrong for you to also dwell upon some of the general wisdom that you gain from such courses. So that is what you should keep in mind. In terms of homosexuality, you've said a lot about it. We discussed it extensively yesterday and the day before and all that. And again, you must remember that you're a law student. You don't have to be very emotional about questions. It's not about you being religious or you not being religious. It's not about you being a good person or being a bad person. Law exams and legal issues have got nothing to do with that. So forget about your personal morality and your personal religion when you're dealing with law paper. Think as a student of the law first and not as someone who professes a particular religion. So let's get that in mind. So homosexuality, don't just brush it aside and say that the Old Testament or the Quran or whatever condemns it and that's it. No. If you did that, you would not have addressed the question as a law student. You need to be systematic. Homosexuality, don't forget, first of all, has got jurisprudential dimension. The relationship between, if you like, a law and morality. How far should law regulate morality, and especially like the people's private space, people's preferences and things like that. And you remember, criminal law, the very famous Wolfenden report, which eventually led to decriminalization of sodomy and so on in the UK. All those things very important. And then the issue about J.S. Mill's no harm no principle. J.S. Mill made the argument that, well, the law should not prescribe or prohibit anything which does not cause harm to another person. In other words, he argues that if you are doing something and it doesn't cause harm to another person, it shouldn't be the business of the law. So therefore, can we say that consensual homosexuality or LGBT practices and so on, is this something going by, let's say, that J.S. Mill's no harm principle? Is this something which causes harm to another person, for which reason the law and society should be interested in legislating it? So those are some of the things. So these are, if you like, a very generalized legal philosophy aspect. Before you come to the human rights dimension again, if we look at the Constitution, as we have discussed before, we don't have explicit recognition of LGBTI rights. At the same time, we don't also have what do you call that, explicit proscription of it. And a lot of arguments are made that if you take Article 33, Clause 5, and so on, the fact that the human rights recognized there are not exhaustive and all that leads some people to think that you should be able to find out if in some other democracies and also under international human rights systems and all that, if, for example, such rights are recognized, then it may also have to be recognized in Ghana and all that. And I will take the Constitutional Review Commission work in 2010, where the issue of whether same-sex marriage should be explicitly rejected. In other words, as whether marriage should be defined as a union between heterosexuals, whether it should be incorporated directly in our law so that LGBTI will completely be outlawed. The commission, the Constitutional Review Commission, if you look at the report, made the point that, well, they were not going to make any recommendation, but just to leave it to the courts, for the court to actually interpret as whether our constitution and, for that matter, our legal system recognizes LGBTI, homosexuality, and so on. So it's very much open subject. There's not so much about correct answer, but it's so much about how persuasive you are. And then your persuasiveness is dependent upon appropriate use or deployment of your legal resources like your understanding of general principles of law. Please, the person whose child is talking, mute your mic. Hi. Mute your mic so that it doesn't come into the class. Otherwise, you remove you and put you in the waiting room. Thank you. Yeah, so that is about that. We don't really, of course, then we go to the, yesterday, I think the point was made by either Bassett or Ezekiel or myself that you cannot do justice to homosexuality but also not showing awareness that the Criminal Offences Act has got something to say about the unnatural carnal knowledge and so on and so forth. Yeah, so these are some of the initial thoughts that we give. So I'm going to yield to my other panelists who come in, but the bottom line is that these type of general issues, when you get them all the time, remember that you are a law student. And for that matter, you are thinking about them. You should be influenced by your legal knowledge, not by your religious convictions, not by your social preferences, and so on. Okay, so my panelists, let me find out those who are here. Ezekiel, are you around?
Yes, Doc, I'm here.
Yeah, so we'll make some inputs.
Right, not much. So I perfectly agree with what you are saying, obviously. Yes, so on the issue of corruption, as you rightly said, when we are looking at how the Ghanaian legal architecture has sought to deal with the issue of corruption, as you rightly indicated, first of all, you have to look at it from the perspective of the Constitution, where we see in the Constitution that there have been specialized institutions that have been created in one way or the other to check against public officers who are likely to conflict themselves and also who are likely to commit corruption and all that. So as you rightly mentioned like this, when you look at Article 187, Clause 1 of the Constitution, you will clearly see that the office of the Auditor General has been created over there. And the key responsibility of the office of the Auditor General, as can be gleaned from Clause 2, is to vet all public offices, including universities and other corporations that have been established by an act of parliament, which is a public corporation in that regard. So you can clearly see that this institution, for instance, is there to check against the proper account of public office holders with regards to the office that they occupy. And you also mentioned about the code of conduct, as we can glean from the Constitution. I think Article 284 and all that. I think when you look at Article 286 was one of the Constitution. Over there too, we see the constitutional imperative that has been created to allow certain public office holders, or let me say public office holders, to make declarations of assets that they have even before they assume office and all that. So I think all these mechanisms are there to check against, first of all, the fact that you don't misappropriate public money, and also the fact that you are not likely to be in a situation whereby you act in conflict to your interest in relation to your functions of your office. Then I also think that even outside the Constitution, they may also look at some of the statutory institutions, specifically the Office of the Special Prosecutor, which was created by the
recently,
yes, the Office of the Special Prosecutor, that is 2017 Act 959. You can clearly see that the object of the office is to tame corruption, be it in the public space and also in the private space. So I think that in addition to discussing the Auditor General and some of the constitutional mechanism that has been created to check corruption, they have to also look at the Office of the Special Prosecutor and the power that it has. For instance, the power to seize property, the power to freeze someone's asset once there's suspected corruption, and then come to the conclusion that all of these are legal mechanisms within the Ghana's legal system that is used to check corruption. Then on the issue of homosexuality, I will agree with you on the score that they have to look at the Worthington report and all those kind of things. Now, one thing that they must also note is that our Criminal Act, that is 1960 Act 29, does not expressly criminalize homosexuality per se. What it does is to criminalize unnatural carnal knowledge. So what it means is that I can express myself to be a gay, or I can express myself to be a lesbian, but until I engage in such activity of, let's say, having same-sex sexual intercourse with a fellow human being, I cannot be convicted under the provision in question. So I think Professor Atuguba, the Dean of the University of Ghana, has a very well-written article when it comes to the issue of homosexuality in Ghana. So I think they can just Google online homosexuality article by Professor Atuguba. It will give them a very nice exegesis on all the issues regarding the homosexuality in Ghana. But just to mention the import of Article 33 clause 5, which is the non-entrenched right, you also said they have to discuss. They must also bear in mind that there are decisions of the Supreme Court that are sought to interpret Article 33 clause 5 of the Constitution. For example, if they remember the Lotto case, for instance, it was one of the things that the Supreme Court sought to interpret. And if my memory serves me right, one of the things that the Supreme Court said is that Article 33 clause 5 relates to all other human rights, which are even recognized under international human rights systems, which have not expressly been included in the Constitution. So in that regard, issues about looking at provisions of the African Charter, the ICCPR, and even the international human rights architecture in general, and its position or posture toward the recognition of sexual minority rights, I think may also be useful in their discussion in this particular regard. And they must also bear in mind that just as they make advocacy for the recognition or the non-recognition of sexual minority rights in Ghana in terms of Article 33 clause 5 of the Constitution, they must also pay attention to the directive principles of state policy about what you call the, I think, Article 39 on the cultural objectives of the state, right, whereby Ghana is supposed to ensure that positive traditional values and cultural values are more or less like instilled in this population and all those kind of things. So they have to do a balancing exercise as to how, if we recognize sexual minority rights in terms of Article 33 clause 5, how will it affect or have an effect on the cultural objectives of the state. And then again, they can also bear in mind Article 40 of the Constitution, whereby the president, when dealing with other nations, are to bear in mind the principles of the United Nations, the African Union, among other international organizations that Ghana is a member of. All of these, I think that they can draw inspiration from to draw the argument as to whether or not, yes, we should recognize homosexuality as part of Ghana, or we shouldn't recognize this. So that is what I will say about the homosexuality. Then turning to the Galamsey issue, when you look at the Constitution once again, there isn't any provision that talks about the right of an individual to a satisfactory environment per se. There is no such provision like that. But then again, when you look at the terms of Article 33 clause 5 of the Constitution, we can bring the right to satisfactory environment or a healthy environment within the context of Article 33 clause 5 in that particular regard. So if they are to look at Galamsey, I think that they can start the discussion from that perspective as well, talking at it from Article 33 clause 5 of the Constitution, so that if they are able to understand Article 33 clause 5 to include such human rights that are guaranteed even under international treaties, then, for instance, one can make the point that when you look at the African Charter, for instance, and Article 24, there is the right of every person to a satisfactory environment in that particular regard. And for that reason, since Ghana is a state party to the African Charter, we can actually say that in terms of Article 33 clause 5 of the Constitution, the right to satisfactory environment has been guaranteed. And for that reason, the practice of Galamsey, where water bodies are being destroyed, incessant deforestation, among other effects, are being felt by the people in the local communities, is something that the Constitution, I think, can look at it from that particular regard. And so they must also, in that discussion, bear in mind that if there is any decision that where the Supreme Court, for instance, have relied on the African Charter, I think is something that will be very more informing to boost up the discussion that they are making in that regard. So that is all that I will say for this one. Thank you.
All right, thank you. Thank you, Ezekiel. Thank you very much. And then for the Galamsey, we need to also be a little bit more practical about it. So first of all, we have to appreciate the effects or the consequences, the effects or the impact of Galamsey, and we must also bring our mind to what we call the sustainable development. And those of you who've done international human rights law, international environmental law before, what we call the intergenerational equity. The fact that the present generation use of the environment should not jeopardize the ability of future generation to also use the resources of the environment for their own benefit and also sustain themselves. So what we call, if you look at the Canadian case of mine opposer, intergenerational equity. So like Galamsey, of course, undermines the principle of intergenerational equity. And there's also dimension on what they call the environmental protection authority, the EPA, because Galamsey takes place in the environment. And as we know, if you are going to do any development in the environment, you're supposed to have what they call the EIA, environmental impact assessment and all that. So if you are discussing all this, it's not really the case that we don't have the legal framework which enable us to contain Galamsey. So I think that should not just be the focus, because if we do that, it will let it appear that we are not aware that there are various aspects of our law which, if adhered to or properly implemented, should not let Galamsey happen in the way that we are seeing it. So you should also argue from other lack of or weak enforcement culture, right? Weak enforcement culture on the part of those who are supposed to enforce and implement the law and all that. Okay, so we will leave that here, and then let's take another issue. Unless my other panelist, David, are you here?
Yes, sir.
Yeah, David,
Sir, I'm here.
We have some inputs to make, and then I'll come to Adjoa as someone. Is Belinda here? Is Loretta here? Okay, is Lawyer Tika here? Okay, so anyway, let's take David.
So, with the Galamsey issue, one thing I want to add to what you said and what Ezekiel said is that our students should advert their minds to Article 41K of the Constitution, 1992. So Article 41K gives citizens the responsibility to protect and safeguard the environment. So they should advert their mind to Article 41K. And then we have this act, Minerals and Mining Act 2006, Act 703. Act 703, Minerals and Mining Act. You see, when you check Section 82 of that act, it prohibits small-scale mining, except with license. So the condition is that you need to get a license before you can engage in small-scale mining. That is Section 82 of Act 703. And how do you get a license? You get the license through the minister in charge of mines, and that is granted by Section 5 of that act. So under Section 5 of that act, you need a license from the minister in charge of mines or natural resources in order to engage in small-scale mining. Then somebody will also ask about issues of Chinese or other foreign nationals, Aisha Wan and other foreign nationals in Ghana. You see, when you look at Section 83 of the same act, Act 703, it prohibits foreign nationals from engaging in small-scale mining. So they should check that section as well. So all foreign nationals are not supposed to engage in small-scale mining. They cannot also front Ghanaians as such. So they should check these provisions as we move along. If there are any new provisions that we can add up, we can add to it, sir.
Okay, all right. Thank you very much. Thank you very much, David. Adjoa, you want to make any input?
Hello.
Yes.
Hello, Doc.
Hello.
Yes, go ahead.
Hello, Doc.
Yes, TK, yes.
All right.
Yeah, TK.
The input, I'll make a very short input to the homosexuality. And what I want students to take notice is that is one in the 70s or so, it was one of the sexual perversions. Now, they are advocating that it should be legalized in our part of the world. Pedophiles, voyeurs, all other sexual perversions are also advocating for the right to engage in, when a person is a pedophile, they engage in sexual intercourse with pre-pubescent kids below 16 or so. Now, in your conclusion or introduction, you can add that as part of the sexual perversion. You mentioned examples of the sexual perversion that were part of the American Psychological Society's psychological illness. It was psychological illness at the time, but through advocacy, they were able to have their name, the LGBTs were able to have their name expunged.
Okay, I think you've lost, I think, TK, maybe network issues. Yeah, TK. Okay, Ajua, any other point before we take another issue? I mean, there's a network issue, you cannot hear TK. Yeah.
To add, Doc.
Yes, Ajua, go ahead. I think we're not getting here too. Okay, then let's take another person. Hilda, Frida, Sam. Yes. Yes, go ahead, Hilda.
So let's say
Hilda, go ahead. Yes, let's hear you.
if you ask the question on how the common law tradition and how the common law system has affected the
can you start? You said if you ask a question on what has affected
how
what?
the common law system has affected Ghana legal system.
Okay. So
How
how
do we go about?
okay, so how the common law has affected Ghana legal system? Is that the question?
Yes, please.
Okay, so how the common law has affected the Ghana legal system. Okay, that's interesting. Yeah, so this is one of those, very general question as well. So assuming you have this question, you could, for example, go about it this way. Of course, this is an essay question. And yesterday, as we indicated, is a good practice to put your thought down so that you arrange the points well. So you must have your introduction, and then the introduction, you explain what the common law is. First of all, you explain the common law and let us know that the common law is a term of art in a sense that it has a certain fixed meaning among lawyers or those who are familiar with the law. First of all, the common law refers to, as we know from your legal system, I don't need to deliver the point, the law which developed dating back to the 1066 conquest, of present-day England by the Normans and all that, through pari decisis or case law. Yeah, so that is generally what we understand like the common law to be. So it's a judgment law, as you will notice, and also supplemented by subsequent development of principles of fairness we call equity, based upon good conscience and fairness. So that is what we generally understand the common law to be. Then you make the point that in Ghana, under Article 11 of the Constitution, we have what we call like the common law of Ghana. And then the common law of Ghana refers to three, if you like, main things. What we generally call the common law, as we have explained, as the body of law which developed going back to the 11th century, gradually through like the judgment law and all that, and also the doctrines of equity, which developed subsequently to mitigate the rigors or the harshness of the common law, and which reflect things which are mirror notions of fairness, justice, good conscience, as reflected in what we call like the maxims of equity. You can recite some of them. He who comes to equity must come with clean hands, equality is equity, delay defeats equity, and so on. Equity will suffer no wrong to do that remedy, meaning that equity is able to give remedy so long as you can demonstrate that your right or interest has been violated. And the remedies include specific performance, injunction, rescission, rectification, and so on. Then you also made the point that the third component of our common law of Ghana is what we call the customary law, right? The customary law, and customary law has been defined. Rules, of course, rules set by custom applicable to particular communities is in Ghana, and also such rules as determined by the superior courts, in Ghana. And then you make the point that the customary law is unlike what the view used to be some years ago. In the case you call like the Angu versus Sata, where allegation as resistance of customary law, for example, was approached as a question of fact. Now, since attainment of Republican status consistently, or of course, at including the Present Cause Act at 459 as amended, treats customary law as a question of law. And if you look at the Cause Act, it is the duty of the judge to actually ascertain whether an alleged rule of customary law is really a customary law or not, and the procedures are there. So those are some of the points that you have to make. And again, you also have to make the point that the common law has introduced what we call the plural. We have what we call the plural system. So Ghana legal system is said to be pluralistic in the sense that we have the received common law, right? The received common law and related Westminster style legislation that we have developed on one side, and at the same time, we also have our customary law, and then the associated chieftaincy institution and all that running side by side. So that means that our legal system is not just monolithic. It's not just reflecting only the English received law as we know it. And if I understand your question again, you said that how the common law has modified or shaped the Ghana legal system. Yeah, so crucial to our legal system, the doctrine of judicial precedence. Judicial precedent, you explain it to me in the practice where we use like the judge-made law to govern matters which have got the material facts as ones, which have been decided before in the form of like a precedent and all that. And this works through the hierarchy of the courts from the superior courts. So the Supreme Court, as you know, is not bound to follow the decision of any court. It may follow its own decision, and then it may depart from it when it considers its right to do so. The decision of the Supreme Court is binding upon the Court of Appeal and no other court below it, and so on and so forth. So you canvass some of these points. So as I said, it's really general. Assuming you have like a general question, like maybe another point you could still make is about the jury trial, right? The jury trial, and also the adversarial litigation that we have, because all these things are reflections of the common law. Until maybe recent times, there's an effort to go back to what we call the alternative dispute resolution, which reflect an aspect of our own traditional system of dispute resolution and all that. Okay, so I will yield for my colleagues to come in. Ezekiel, Latik, are you there? Stanley, are you there? Okay. Okay, then we can take Ezekiel if TK is not there.
Doc, I think what I had in mind is what you just said. I wanted to add a bit about the judicial precedent, which underpins the operation of the Ghana legal system. So I wanted to make the point that one of the basic ways that we can see the common law as received influencing the Ghana legal system is through the operation of the judicial precedent system and the Ghana legal system. Because you realize that just as the theory is developed, you can see that day in, day out, our own courts are being bound by their own decisions. For instance, in the case of the Supreme Court, you can also see how other courts that fall below the Supreme Court are being entreated to follow the decisions of the Supreme Court. For instance, the High Court and then the Court of Appeal and all other inferior courts in Ghana being entreated to follow the decisions of the Supreme Court in terms of Article 129. So for me, after they've discussed all the things that you've said to them about the common law of Ghana and all that, the component and the various explanations that you gave, then the point that I want them to make is about the judicial precedent and show, even from the Constitution and even from decided cases, how the doctrine of judicial precedent, which is something that is cardinal to the English common law, had been influencing our legal system in the practice and the decide of cases in court. So that's what I wanted to say, but you already made that point, so thank you.
All right, thank you, Ezekiel. Is David around?
Yes, Doc. Doc, I'm around.
Yes, please. You want to make some inputs?
Doc, I think with this question, you've dealt with it extensively, sir.
Okay. Ajua, you want to make any input?
Doc. No, Doc, please, you've dealt with it. Thank you.
Is lawyer TK back? Is lawyer Gertrude here? Okay. All right. So I don't see any hands. So I want to presume that you don't have questions. We are just going to give you a minute word of final advice, and then we draw the curtain down because we are not here. I haven't seen any hands up. Okay, so just last minute, a few words we tell you is that.
Excuse me, Doc.
Yeah.
There are lots of questions in the chat, which is in need of
addressing. So just put up your hand and then say them so that we can all hear it. Yeah, Emmanuel Soguluzu, yeah, your hand is up.
Yes.
Yes.
Yes, Doc. We are having a lot of issues or information coming from our communication minister with regard to the deadlines of SIM registration as is ongoing. And as we stand now, if it's there, I don't know, but we don't have any legal document or any law backing the registration and also giving us deadlines. With the possibility of it coming to an end or the deadline coming to take effect this September as announced by the minister. What is the legal implication of this as is something that is current and some of our
for the SIM registration, I don't agree that we don't have any law backing it, but I'll go to my panelists and then come back to because there's some sort of a legal justification for what they are probably doing. Lawyer Tika, are you back? Okay.
Yes, Doc.
Yeah. So will you have a bite on this issue?
Doc, which one? I didn't hear the question.
The question about the person thinks that there's no legal justification for how the Minister of Communication is going about SIM registration, threatening to block people's unregistered SIM. and so on. Are you clear? I think TK is not. Yeah, okay. All right. So, any of my panelists?
Hello.
Yes, Ezekiel.
Yes. So I have a very little idea in this area, but I think I can share with them. Yes. So one, we are looking at a company or telecommunication companies, okay, and their relationship with their various customers. That's on one hand. And on the other hand, we are looking at government interventions, okay, that can be made in terms of the operations of companies and their relations with their customers. So in terms of the relationship between the telcos and then their customers, I would probably say that we can situate it in the law of contract, in the sense that I believe that at the point whereby you went to acquire the SIM card, you provided your details, and then they registered the SIM card for you. I believe that there was some sort of a binding agreement that you had with the telecommunication network, first of all, for them to provide you with access to their network so that you can be able to make calls and send messages, use data and all that. And in return, you will also be paying for the services that they give you. So that is what I believe will be the other side, one side of it. That's a contractual relationship between the customers and then the telcos. But now the question then becomes, if two parties engage in a contractual arrangement, can we say that the contract is to the exclusion of government interventions? And my answer to that would be no. In as much as the parties will have what you call the freedom of contract to engage on their terms and all that, the government or the state, at the end of the day, can in one way or the other also intervene in the performance of said contract and even make regulations as to the performance of that particular contract in question. And bear in mind that all of these telecommunications networks are corporate bodies in the sense that they have been incorporated in accordance with the company's law of Ghana and all that. And being corporate bodies, and they fall under some ministry, it is imperative that such ministries will have the power in the circumstances to make certain regulations to guide their conduct. So if those regulations that are being made by the minister in one way or the other impede the performance of their contractual relationship with the customer, then I believe that that one will be justified on the basis of law. Because if, bear in mind that the object of all these SIM card registration and all that is in accordance with the policy of the government to digitalize the economy and also, among other, to ensure cyber security and all that. So I believe that there is a justification for that. And that justification for that particular re-registration, in one way or the other, yes, it may impact your relationship with the telcos, telecommunications network and all that, but it wouldn't make it unlawful in the circumstances for them to do that. So that is my take on this.
And Ezekiel, just to supply this information, if we look at the Electronic Communications Act 2008 at 775, and in section 97 thereof, give power to the minister responsible for communication to make regulations in the form of LI. And pursuant to that power, LI 2006 was made in 2011, called the Subscriber Identity Module Registration Regulation. So as far back as 2011, there has been a legislative framework to actually provide for, registration of SIM and various aspects of it, except that the state has not been very strict about enforcement and to say that if you have been registered, we are going to instruct the particular network operator not to allow you to enjoy the services. Yeah, so I think in that respect, there's a legal justification. And rightly, as Ezekiel indicated, there's a need for regulation for purposes of not only digitization, but for purposes of fighting crime. If you are there and somebody use any number to call you, send you threatening message, or to just anything which will cause fear and panic in you. Now, how would the law enforcement agents be able to protect you by helping to track the person? But if you have a regime where everyone has registered the same and so on and so forth, it's very easy for us to be able to hold the people responsible for wrongdoing and so on. Yeah, so apart from the general legality, there's also a bit of like a general common sense dimension of it. Just imagine those days, one person can have about 10 or 5 SIM cards. He will put one in, we just remove it, and we're doing all manner of things. Yeah. Okay, but we will take our other panelists if they have a few things to add before we leave this. David.
Yes, sir.
Yeah, you want to add something?
Sir, no, I think just to add the aspect of where investors come or companies come to Ghana, invest their monies, and people take their monies without repaying. I'm talking about this new business, the Momo business, the Vodafone cash business. Okay. You see, the companies have always complained that people take their monies and then abandon the SIM cards. So with this registration system, it's likely that people who take Momo or take quick loans and other loans from the companies can be tracked, and the companies can recover their monies, so that Ghana can attract the investment that it needs for development purposes, sir.
Okay, all right, thank you. Yeah, I think because of time, we'll not belabor issues. Once we get a good sense about the particular issue, then you move on. Okay, so Dan, you want to say something?
Good evening, Doc. Please, under citizenship, what is the difference between registration and naturalization?
Registration and naturalization. Okay. Okay, Ajua, you want to have a bite?
Yes, Doc.
Yes, take it. Yeah, take it, go ahead. Naturalization as opposed to registration under citizenship law. Okay, if we look at the Constitution, particularly Chapter 3, as well as the Citizenship Act, apart from citizenship by birth or by descent, it is also possible for you to become a citizen of Ghana, either through registration or through naturalization. But this question, I would like to know, what is the difference between the two? Okay, so in the case of naturalization, for example, you don't need, for example, to have, let's say, married, right? You are supposed to have lived in the country for a certain number of years, and then you identify yourself, as a Ghanaian. You become like assimilated. You can, as it were, speak some of the local languages, and you get people to, for example, testify that you are like a good person. So just open my Citizenship Act at 591. So let me get the exact provision for you. Good. So we have the citizen by naturalization governed by section 13. So let's look at section 13. Good. So the minister may, with approval of the president, grant a certificate of naturalization to a person of age and capacity who satisfy the minister that he is qualified under section 14 of this act for naturalization. A person to whom certificate of naturalization is granted shall take the oath of allegiance and become a citizen by naturalization from the date on which the oath of allegiance is taken. So to qualify to be given citizenship through naturalization, you must bring yourself under section 14, which among other things says that you must have resided in Ghana for a period of 12 months before you put in the application for naturalization. And this 12 months should be continuous, meaning that you must have remained continuously for 12 months before putting the application. And again, during 7 years before you made the application, that before you put in the application, 7 years before the 12 months in which you're supposed to remain continuously in Ghana, you have lived in Ghana. If you put the period that you live in Ghana all together, like you aggregate them, if you put everything together, you must have lived in Ghana for a period not less than 5 years. So meaning that if you are dealing with 7 years, okay, the law is that before you put in the application for naturalization, 12 continuous months, you must have been in Ghana. Another requirement is that 7 years preceding that 12 months, if you put the time that you've stayed in Ghana together, cumulative or on aggregate, we should get, let's say, 5 years, okay? Yeah. Then the third requirement is that you must be of good character and is attested to in writing by 2 Ghanaians, being notary public, lawyers, or senior public officers. Recently, I did one for a Nigerian who wants to acquire citizenship by naturalization. So a Ghanaian who is either a senior public officer or notary public or lawyer saying that, yes, this person is of good character. 4, the applicant must not have been sentenced to any period of imprisonment in Ghana or anywhere for an offense recognized by law in Ghana, meaning that you must not have any criminal record. You want to acquire citizenship by naturalization. And as I said, 5th, you must be able to speak and understand an indigenous Ghanaian language. So that is the assimilation, if you like it. You must be able to, you cannot say you want to acquire Ghanaian citizenship by naturalization, and you cannot speak even a few words in any of the local languages. That will not be permissible. 6, the applicant must be a person who has made or who is capable of making substantial contribution to the progress or advancement in any area of national activity. Yes, so you show that you are bringing something to enhance life in Ghana in one way or the other. And then 8, the applicant must be a person who has been assimilated into the Ghanaian way of life, or who can easily be so assimilated. So being assimilated means that you should be able to identify with one of the Ghanaian cultures. You can eat apele, for example, or eat fufu, or can dance abaja, or bobobo, or kiti, or those kind of assimilation. You should be able to identify with the Ghanaian way of life. And again, the applicant must have the intention to reside permanently in Ghana if he gets the certificate. So if you want to acquire citizenship by naturalization, you don't just get it and then go and live in another country. No. And finally, the applicant must possess a valid resident permit on the date of his application. So all these requirements are more or less conjunctive, meaning that you must be able to satisfy all of them before you can get citizenship by naturalization under the Citizenship Act and also under the Constitution, as it were. But we have an exemption or exception. It is permissible, if we look at the section 14.2, for the Minister for Interior, for example, in special circumstances, which the minister thinks fit, and with the approval of the president, allow a continuous period of 12 months, ending not more than 6 months before the day. So instead of you having to stay continuously for 12 months before you can put in the application, in appropriate cases where the minister and the president grants you the permission, if you've done just 6 months, you'll be able to take care of that. So these are some of the things that you should have in mind, talking about citizenship by naturalization. Now, citizenship by registration on the other hand, as governed by Section 10 of the Citizenship Act, Act 591, also very not the same, but like similar requirements. You must be of age, meaning that you must not be a minor, and then you must also fall within an approved country. There are some countries, if, for example, you come from a particular country, you are not recognized to be able to acquire Ghanaian citizenship by registration, because the minister, publishes an airline and country which are, for example, excluded or which are included as being countries whose citizens could be eligible for acquiring Ghanaian citizenship by registration. So once you fall within that, then you must show that you have good character, you ordinarily reside in Ghana. Ordinarily reside in Ghana does not mean that you stayed here all along, but even if you go and come, there should be evidence that you have some reasonable abode or presence in Ghana, as you are, if you like, entry of a domicile, as it were. And then the third requirement for citizenship by registration, as opposed to naturalization, is also that you must have been a resident throughout the period of 5 years or shorter period, as the minister in special circumstances may accept before you put in the application. So just very similar, but you look at the naturalization, it says that if you take 7 years preceding the 12 months that you're supposed to live continuously before you put in the application, 5 years in aggregation or in total should have been spent, if you like, continuously in Ghana. If you put everything together. So that is the naturalization, but for the registration is a bit relaxed. It's just the 5 years, or it's even possible for it to be, to be short, as it were. So let us keep that in mind. And again, the fourth requirement is that if you want to acquire citizenship by registration, you should be able to speak and understand indigenous language of Ghana. There is no requirement for assimilation. So maybe the person who has a question, one difference is also that for us in citizenship by naturalization, you must also not only speak Ghanaian language, you must also have assimilated. That is, you identify with the aspect of a Ghanaian culture. In the case of citizenship by registration, there is no such requirement. So let us keep that in mind. And another point to also note is that a person who is not a citizen and is or was married to a citizen may, upon application, be registered as a citizen. Yes, if you are married to a Ghanaian, of course, that makes it easy. But where you are not married to a Ghanaian, you can still acquire citizenship by registration. But if you acquire your citizenship by registration as a result of marriage, the fact that the marriage has been dissolved will not lead to your citizenship coming to an end, unless you yourself decide to renounce your citizenship. Yeah, so we'll leave it here. Otherwise, we take all the time here, but I'll take my panelists if they have some few other points to make with respect to the distinction between citizenship by naturalization and by registration. Ezekiel, anything?
Doc, I've listened to you carefully. I have nothing useful to add. I concur. Thank you.
Okay. TK, David, Ajua. Is David there?
Yes, Doc, I'm here, Doc.
Any addition?
Doc, no, please.
Okay, then let's take Joshua Abba.
Yeah, Doc, I'm very grateful. Doc, I want to know if the Asin Central MP, the lawmaker quitting, does it fall under naturalization or registration?
I'm not clear on what you mean, but let me, do you want to find out whether his citizenship is by registration or by naturalization?
By registration or naturalization?
No, I think, if I'm not mistaken, he was, I think, originally Ghanaian, and he also acquired citizenship of another country, right? And
yeah,
you know, our constitution says that you cannot be a citizen of another country and also be a member of parliament and so on. I think that is the point, but I will let my panelists also come in. David, you want to share something?
Yes, Doc.
Yeah.
Yeah, Doc, I think with Honorable Kwesi, that is a case that he's a Ghanaian and he acquired a different nationality. And then the laws of Ghana says that before you become a member of parliament, you have to renounce any other citizenship that you have acquired before you become a member of parliament in Ghana. And the case, I know that you are not going into the case, but it is that by the time he filed his nomination to become an MP, it is alleged that he was still a citizen of another country. You understand? So his is not about registration or a naturalization. His is straight, he's a Ghanaian by birth, but acquired a different citizenship. And we don't know how he acquired it over there. But in Ghana, you can acquire citizenship by registration if you're a foreigner under Section 10 by registration, and then under Section 13 by naturalization. But for Kwesi, he's a Ghanaian by birth.
Okay. All right. Thank you. Adjoa or lawyer TK or Ezekiel, any addition? Ezekiel, are you there? I think we've lost him. Okay, yeah, I think that is it. Okay, so let's take another person. I think is the next 15 minutes. We should be ending probably this so that you can go and rest and have a fresh mind. Any other question? Okay, there's no hand up. So since there's no hand up, just to recap what we'll be telling you before, you're going to do either two types of question or you're going to do one question throughout. But hopefully, we hope that probably one problem-based question, one essay question, or worst case scenario, two essay questions or two problem-based questions, whatever it is. The question will be either essay or problem or combination of both. For problem-based question, we've told you over and over again from your various law faculties, from our online lessons, the various revision centers that we've gone. And I've also made even like some recording on IRAC, reminding you that you must stick to the IRAC if you get any problem-based question at all, so that you identify the area, you raise the issues or in your introduction, and you take an issue as a topic or heading. Underneath, you tell us what the relevant principles of law are. And you do that in a form of like a proposition, that is a topic sentence, followed immediately by the particular authority. If it's the provision of the Constitution or it's a provision of an act of parliament, or it is a case law, as you make the topic statement, either column, then you state the case law or the particular authority, or you made the topic sentence, the into brackets, you write it against whatever it is. You do all that under that before you do the analysis and application. So doing the analysis and application, as you say, simply means that you are trying to show from the facts that you have as whether they satisfy the particular, the principle that you have stated. Olu say that the portion of the facts that you are familiar with from the story, do they satisfy that or they don't satisfy that, as it were? So that is the sense of application and analysis. And then once you do that, what it means is that you've concluded on that issue, you've answered that issue, then you move on to another issue. You go through but let's assume that in doing the application and the analysis, there may probably be a case whose facts are very similar to what you're dealing with. And for that matter, the decision are very much applicable. And you want to make that the particular conclusion or the analysis or the inference that you're making is, for example, buttressed or supported by this particular decision, where so and so and so, then you can open it up and tell us what happened in that case and then how the court held or concluded that. So that is the only time when you're doing like the IRAC, where you need to really tell us more about what happened in the case. Otherwise, the first part, when you outline the principles and the authorities, that is not where you're going to tell us in detail what happened in each of the cases. No, it's not necessary. You only tell us what happened in maybe in a particular case or some relevant case where you are going to use that to, for example, buttress a certain argument to show that it is on all fours or is distinguishable or something like that, as it were. Then repeat that for all the issues, and then you draw your big conclusion. And if you were asked to, for example, advise the parties, then you have to actually, having done all the analysis in order, then you do that, and then you are able to actually do what the examiner said you should do. And yesterday and the day before, we made the point that it doesn't really matter whether the question said identify and resolve the issues or what legal issues arise or whatever, or advise the parties. Even if the question says advise the parties, it will still, so long as a problem-based question, you still have to go to IRAC to be able to do justice to what the question is saying. So let us keep that in mind. Yeah, I think these are what I would say by way of the IRAC. I will very soon come to my panelists for them to say their few words, and then we will draw the curtain down. And then for the essay questions, as we have said time and again, get your points well organized. And even yesterday, for example, I think Dr. Bassett made a suggestion, which I think is a useful one, that a good student will, for example, try and use maybe either the first page, right? The first page or whatever of a script to plan his answer, so that the points are, for example, clearly written over there before you even start going and develop them. And if anybody takes your script, the person will know that there is a well-organized student who has given some thoughts to the answer before actually putting it for examination or for marking and so on. So let us look at that. Let's be logical in how we present our answers. and then use your time well. Probably a particular question that you'll be discussing with your friend or your revision, or even in some of these discussions that we do, let's assume you go and that question is there. It doesn't mean that you use all the time to answer only that question and leave no time for the other question. Mind you, you're to answer 2 questions, and there's no way that you get, let's say, 50/50 in the question the one you use all the time to answer. And if, assuming you even get a 40/50, you get 0/50 in the other one, you are still in a very dangerous situation, isn't it? So manage your time well. Both questions must receive equal answers or attention. And then when you finish, you read over and you'll be able to see few errors. If you plan your answer before writing, you will not be one of those students when you are marking their script. You notice that they've written about 1.5 page, and then they will cancel the 1.5 page before they start all over, meaning that when the person started, he didn't think through, just started writing. So let us avoid that. Okay, so that is very important. And again, let me say that much as we encourage you to do what we call the introduction to the essay question, be careful. Some students, when you're marking, some examiners are marking your scripts, it can be very annoying where they write about 2 pages of introduction and they have still not given you a good sense of what they are trying to do, right? Introduction is important, but it should be straightforward to the point. The purpose of introduction is to let us know your understanding of the key idea in the question, and then what you are seeking to do. You give a signposting of what you are seeking to do in that, and then you start. You don't beat about the bush, because if you let your examiner go through 1 full page, 1.5, 2 pages, before you begin to make some sense, it's not good. You make an initial negative impression, and that can affect your overall score. Okay, so I wish you very well, and then good luck. So I will take a few words from my panelists, then we say goodbye to you. Yes, so let's start from Lawyer Stanley Jamfi. Are you there? I think we've lost him. Okay. Then let's start, let's go to Ezekiel. Say.
Right, Doc. I don't have anything to say. I just wish them all the best. I believe that with prayer and supplication, we'll be with them in the spirit. And the good Lord will surely remember them of all the things that they have learned. So I wish you all the best. Go with the mindset of a winner, and then please sleep. You need to sleep and relax. You don't have to stay up all night. It's not good for your mental health and also the ability to even to recall information. So rest and rest well, and so that tomorrow when you go, you'll be able to relax and then write the paper. So I wish you all the best. Thank you very much.
All right, thank you, Ezekiel. Yes, David, and then I come to Ajua.
Yes, Doc. So I am also wishing them all the best and good luck as well. They should check their handwriting. They should write legibly. Handwriting is very key. So if you are making a point and your handwriting is not clear, the examiner will not be able to see what you are trying to portray. So please, your handwriting. Good luck. Wish you success. Thank you, Doc.
All right, thank you. Ajua. Ajua there? Okay, all right. You've lost her. So we thank all the panelists and all those who sacrificed their time. Ezekiel, David, Stanley, Ajua, Bassett. God bless you, and then we wish our students very well. Good luck.